Ladies and gentlemen, please give a warm welcome to the laureate of the 2018 Tom Prize in Rule of Law, Dr. Joseph Raz, and our host, Professor Paul Craig. Good morning, distinguished guests, ladies and gentlemen. Welcome to the Laureate Lecture of the 2018 Tom Prize in Rule of Law. To begin with, we would like to invite to the stage the host of this lecture, Professor Paul Craig, Professor of English Law from Oxford University, to give us the introduction. Ladies and gentlemen, please give a warm welcome to Professor Craig.
Good morning, everybody. It is a very great pleasure to be introducing Professor Joseph Raz, who has been awarded the Tang Prize for the Rule of Law 2018. This is more especially so since his lectures on jurisprudence first introduced me to the subject. Joseph was at that time a fellow and tutor in Balliol College, Oxford, and I was a law student in Oxford from 1970 to 1974. It was readily apparent, even at that relatively early stage in Joseph's career, that he was a leader in the field of analytical legal philosophy. Oxford has a long and prestigious tradition in this area, as exemplified by Herbert Hart's seminal work on the concept of law. Joseph Raz developed and refined the theory of legal positivism as attested to by his first major work, which was entitled The Concept of a Legal System, published in 1970. His position as a leader in this field has been reinforced over the subsequent 45 years, during which he has produced path-breaking works on legal and political philosophy. These works have deepened our understanding of the very nature of law, legal reasoning, and the relationship between law, morality, and freedom. He has written broadly on a wide range of topics, including the rule of law, legal positivism, legitimate authority, normativity, reasons, and perfectionist liberalism. His contributions have taken the form of books, law review articles, book chapters, as well as prestigious lectures. Analytical acuity, philosophical subtlety, and normative rigor are the hallmarks of his scholarship. It is this combination that have made his writings an invaluable source for anyone working in legal, moral, and political philosophy. Let me just share with you one very personal vignette about my time in Oxford. Joseph will probably have forgotten this, but it was a rather wonderful occasion. Joseph was giving a lecture on legal philosophy. I was a graduate student at the time, and Joseph was delivering the lecture. And there was actually a rather annoying student in the audience who put up his hand one time and said, Dr. Raz, can you please tell me the authority for that proposition? The student, imagining that somehow in legal theory, authority for a particular proposition would take the form of a citation to a House of Lords decision or a Supreme Court case, which is obviously not so. Nonetheless, on the first occasion, Joseph treated the question seriously and explained some of the reasoning behind how he got to the position. The time marched on, and a second occasion, the student then put up his hand again and said, Dr. Raz, can you tell me the authority for that proposition. Even as a student, I could see Joseph was getting a little bit irked by this at the time. But nonetheless, he answered in good humor and explained the reasoning which had led him to that position. Another 10 minutes went past, and yet on a third occasion, the student yet again put up his hand in a rather whiny type voice and said, "Dr. Raz, what is the authority for that proposition?" At which point Joseph looked him straight in the eye and said, "It is from my notes," and then moved straight on. I look very much forward to hearing Joseph's insight in his lecture today, which is entitled "The Law's Own Virtue." Please welcome this year's Tang Laureate in the Rule of Law, Professor Joseph Raz.
Thank you all for coming. We can think about the rule of law as a virtue the law should possess. It is one of the main virtues the law should have, and as such, exploring it contributes to an understanding of the nature of law and its role in our life. The law is a structure of rules, institutions, practices, and the common understanding that unites them, which normally are an aspect of some social organization, state, city, university, corporation. International law is a possible exception, not being united by its relation to a single corporation, to a single organization. When exploring the role of the law, we study its essential properties, its relations to the organizations whose law it is, and to the people's life and thought more generally. The rule of law, as I will understand it, is a specific virtue or ideal the law should conform to. There is no general agreement about what it is. This lack of agreement is common to important normative institutions and principles, like freedom of speech, and is often a source of strength. People unite in supporting such institutions and principles in spite of diverse views about their nature. There is no point in verbal disputes about which ideals deserve to be called the rule of law, but there is a point in clarity and avoiding confusion. Hence my proposal, which is really an endorsement of one common view. I will explore the nature of the rule of law by drawing an analogy with the conditions of individual prosperity. People are born into a society with its cultures and norms. They acculturate and learn to make their own life, creatively using the opportunities and observing the limits set by the cultural norms. A process that is enabled by familiarity and understanding how things work, and predictability, ability to plan and make decisions for the future because one can, within limits, predict their impact. Absent that enabling background, disorientation, loss of sense of one's command of oneself and one's situation, loss of self-respect ensue. Now think of the law. Governments come to power in an existing social and legal culture, and norms whose stability and predictability are essential to the well-being of individuals. The rule of law consists of the principles that constrain the way government's actions change and apply the law, to make sure, among other things, that they maintain stability and predictability, and thus enable individuals to find their way and to live well. Hence, the rule of law principles are not about the content of the law, but about its mode of generation and application. It requires that legal decisions and rules be anchored in stable general doctrines made for publicly available reasons, applied faithfully, observing due process, and more. Importantly, these conditions of individual and social prosperity are universal. Different societies have different cuisines, different social relations and manners, different economic structures, different religions, or none. But all require stability and predictability, and above all, they must be intelligible to those subject to them, for people to feel at home within the framework of the law, and to have the confidence and self-reliance to plan their life. Hence the universality of the rule of law, uniting cultures that otherwise differ and therefore providing a crucial framework for mutual toleration individually and socially, and enabling worldwide cultural and economic exchanges. So I will start with a first step at understanding more precisely the rule of law as it applies to state law, though these ideas can be readily expanded to other contexts. I refer to the rule of law as a virtue possessed by a legal system that conforms to the doctrine of the rule of law and whose public culture resists deviation from it. The doctrine consists of principles united in the rationale and articulating various aspects of that rationale, various ways in which it ought to be implemented. Some of the principles that belong to the doctrine of the rule of law are common to virtually all accounts of the doctrine. Government is by law, meaning first, reasonably clear, secondly, reasonably stable, thirdly, publicly available, fourthly, general rules and standards that are, fifthly, applied prospectively and not retrospectively. So these are my 5 starting principles. What is common to them? What makes them one doctrine rather than a hodgepodge of principles? One popular view is that they make it possible for those subject to the law to find out what it is, and thereby make it possible for the government to know how to govern, and for those subject to the law, subject to the government, to know how they are governed. And the analogy that I started with explains why this is important. But there are problems with this idea, with this explanation of the rationale for the rule of law. The principles that I mentioned, all 5 of them, are vague, allowing of various degrees of compliance. Now that in itself, you would say, is no problem. It is true of many principles. The difficulty is that the rule of law gives no guidance as to the required degree of compliance. Worse still, it is impossible to implement these principles to a very high degree. Discretion is inevitable for the executive and administrative organs and for the courts. Moreover, discretion is desirable. Without it, the law is blind to exceptional circumstances, to the need to refine laws in application and to adjust them to changes in the world. Taken to extreme, the rule of law principles, as I articulated them, militate against any legislation, any changing in the law, which is absurd. So, how are we to respond to that problem? One response is to say, that one should allow for deviation from the principles only to the minimum degree required for adequate governance. But the problem is that there is no such degree. Here and there, in special cases, one can find examples where deviation is necessary and beyond which it should not happen. But that does not amount to a general test of necessity, and no such test can be found. Instead, I suggest, we should realize that the rule of law doctrine has been inadequately identified so far. Perhaps simply only part of it was stated. So without disowning, without discarding the sensible part of the 5 principles, we need to further explore and develop our understanding of the doctrine. We can start again, noting that at least one commonly agreed aim of the rule of law is to avoid arbitrary government. We can state that to take that as a clue, helping with further developing our understanding of the rule of law. First thing to note is that the 5 principles which I've listed as a first step do not eliminate the possibility of arbitrary government. For example, a paradigm case of arbitrary power is the use of public power for the enrichment of those in power or of their friends and relations. And the 5 principles that I mentioned do not exclude self-enrichment. They merely restrict the ways, the means by which it can be achieved. And that shows that pursuing the clue, avoid arbitrary power, may help in enriching our understanding of the rule of law. But what is arbitrary government? What is arbitrary action generally? It is action indifferent to the reasons for and against taking it. Arbitrary government is the use of power that is indifferent to the proper reasons for which that power should be used. What are the reasons that should guide governments? And indifference to which is arbitrary government? Well, governments are constituted by law, and in creating them, the law explicitly or implicitly identifies its purposes, the purposes for which governments may act. It is their nature as governments that they ought to follow and apply the law, though the law may create exceptions which exempt governments from having to obey some laws. But, you might ask, why is it a virtue for governments to obey the law? Well, remember that by its nature, the law claims to possess moral legitimacy, and by their natures, governments are law's instruments for their application and development, for the application and development of the law. So, inasmuch as the rule of law requires governments to be faithful to the law, it is a moral doctrine. But, you may remind me, not all legal systems are morally legitimate. Does it follow that the rule of law does not apply to those which are not? For there is no moral virtue in applying their law. Not quite. What does follow is that its application is more modulated, and that regarding some laws, there may be no reason at all to apply them. But for the most part, as the analogy which guides me throughout this talk with the conditions of individual prosperity shows that there is still reason to follow the law in most cases, even if some of the reasons to follow it may be overridden. The rule of law is not an absolute reason. It's a pro tanto reason, as we say. It can always be conflict with other reasons and sometimes be overridden by them. So 2 crucial points should be borne in mind. First, not every failure of the government to be guided by law is a breach of the rule of law. For the most part, such failure is due to mistakes and incompetence. Even the most conscientious and qualified government is liable to fail in these ways. And such failure does not manifest indifference to the reasons that should guide the government. Second, it would be a mistake to think that obeying the law narrowly understood is the only guide for governmental action. For one thing, inevitably governments have considerable discretionary powers, and for another thing, in interpreting the law, as they must do, they are guided by certain reasons and must avoid others. Is there a general way, then, to characterize which reasons should and which should not guide them? Determining what ends to pursue in the exercise of discretionary powers or in the interpretation of the law is the stuff of ordinary politics, and the rule of law does not review the success of politics. But the very nature of governments as governments produces a clue to the purpose that they may pursue or those which they may not. Arbitrariness, we remember, is indifference to whether governmental action accords with its purposes. And this seems to be a simple and helpful idea. But there are difficulties when we think about it, forcing us, while accepting that the rule of law excludes arbitrary government, to realize that we have further questions to answer. Here is a difficulty. What constitutes indifference by government as to whether it pursues an aim that government may legitimately pursue, both in interpreting the law and in exercising discretionary powers? It cannot depend entirely on the government's claim. And I'll give you a ridiculously simple example. Imagine a government by a sole hereditary ruler, call him Rex. Rex has ordered the purchase of a very expensive diamond ring for his lover. He claims that he was entitled to do so because his lover would be very pleased with the gift. And this is a very good reason for gifts between lovers, using the private property for the purpose. Rex's mistake is failing to realize that even though he controls the public purse, he does not own it. Rex appears to lack the distinction between the rights and powers of governments and the rights and powers of private owners. Perhaps in his country, the distinction does not apply. It has not always applied everywhere. In which case, the rule of law does not apply to his country. If the constitution of his country does recognize a distinction, then his act is against the rule of law, for he cannot claim to have acted in pursuit of a purpose which could be the purpose of government. The difficulty is that, on the one hand, he cannot be said to have acted arbitrarily, that is, in indifference to reason. He thought that he had good reason for his action. On the other hand, his mistake is more basic than an ordinary mistake about the purposes that government should pursue. It is a mistake in thinking that he has the rights of private owners. So, indifference to reason, arbitrary use of power, is only one way in which one can offend against the rule of law. Another is acting for purposes which is clearly not one which governments are entitled to pursue. Doing so is not being indifferent to reason, but is not something that any government can legitimately do. It is excluded by the very nature of government. Therefore, saying that it is excluded is not a matter of taking sides in political debates about which purposes this or that government should pursue. It is no more than insisting that it should act as government. So we come to a new question. What is it to act as a government. Governments are there not to promote their own interests, but that of what? Various suggestions appeal, but I will stop with the most obvious one. The interests of the governed, understood broadly to include the moral interests of the governed. This seems plausible. The justification of rules of law and of governmental actions should be that they are, as we say, in the interest of the governed. Several ideas coalesce around this core. The interests of all the governed is what we have in mind, and they should be given their proper significance and importance. Secondly, the governed, broadly understood, include anyone directly impacted by government action. But the government may have special duties to look after the interests of some people because it is their government in a special way. Governments are custodians of the public interest of those whose government they are. They should be mindful of the interests of others as well. But where those others have their own government, their own custodians, responsibility is shared. Their custodians have special standing to decide how to protect and advance their interest. Our government may not take over that role, the role of their government. So the duty of those whose government it is special. Implementing this is a complex, context-sensitive, and is bound to be controversial. But we can say that governments conform to the rule of law when they act in their exercise of their power according to law. Governments claim to be morally legitimate in part because they are constituted by a legitimate system of law, and that law provides reasons that bind the government that it constitutes. The governments act arbitrarily when not trying to follow the law. The test of conforming to the rule of law, according to the conception of it that I am developing, is acting with manifest intention to serve the interest of the governed, as expressed by the law and its moral proper interpretation and implementation. So you conform so long as you act with manifest intention to serve the interest of the government, as expressed by the law and morally proper interpretation and implementation. This requires conformity to what we know as the main features of public accountability. So we add principles to the 5 we started with. The reasons for which decisions are made should be publicly declared. Now, you may immediately say that this is overstating it, that this is excessive. Surely the reasons for some decisions need not be made public. And this is true. But all rule of law principles, as I've already stated, are pro tanto reasons which can be overridden by conflicting considerations. 7, the process of reaching a decision should be fair and unbiased. 8, it should allow proper opportunities to consider the relevant arguments and information. And here various degrees of representation and hearing are involved. 9th, the decisions should be reasonable relative to their declared purposes. Unreasonable decisions raise doubt as whether they were taken for the declared reasons. If that was your purpose, you wouldn't have done that. You do that, you say that that was your purpose, but this is unbelievable. This is just incredible. 10th, There are presumptive conventions about what constitutes conformity or breach of the rule of law. The burden of establishing that government actions were undertaken in the belief that they serve the interests of the governed is a very heavy one. In practice, the rule of law requirements are met by officials conducting legal business according to conventions of how to do so, how to legislate, adjudicate, issue executive orders, and so on. Conventions that conform to the other requirements of the rule of law, of course. These conventions become involved in all official functions, and they raise a double rebuttable presumption that observing them serves the interest of the governed, and that the officials who follow them act in the interests of the governed, as they see it. 11, my final principle, is that the doctrine of the rule of law and its main implications should be part of the public culture embedded in education and public discourse and taken as obvious and vital by all. The principles it embodies should be above political controversy, though their detailed application and implementation will inevitably not be above such disputes. At this point, I'm skipping part of what is indicated in your handout. And move to section 9.6. And this part of the complete talk, more than what I just delivered, I'm engaged in defending the idea of the rule of law as I articulated it so far. So I hope that what I said is already partly a defense of it, just by appealing to our moral understanding of how government should conduct themselves. But there are more specific defenses and rebuttals of criticism that I'm not going into. But I want to mention one or two points in that context. One very important point that I want to mention is the complex relationship between the rule of law itself being a moral doctrine and other moral principles. I think that it can be described as a two-way street. The rule of law borrows from other moral principles, and it also contributes to the generation of new derivative moral principles. How does it borrow? I mentioned that the implementation of the doctrine requires reliance on conventions which may vary from time to time and from place to place. Now, where there is a moral principle of some weight, so that its violation, even by legal institutions, is rarely justified, and if it deals, among other things, with the way institutions work, then it makes sense to incorporate it into the rule of law doctrine as one of its conventions. And I gave only one example, but there could be others, which is the rule of audi alteram partem. There are general reasons of fairness, independently of the rule of law, general reasons of fairness to listen to a person who might be disadvantaged by a decision. These reasons are pro tanto. I do not have to listen to everyone who may be disadvantaged by something I do, though I have reason to do so when this would be practicable. Now, it makes sense that the requirement that courts and other organs of the law should do so is generally taken to be one of the principles of the rule of law. That is, it is a rebuttable presumption that action of some legal organs is arbitrary and thus a violation of the rule of law, as well as unfair if it violates the audi alteram partem principle. So this is an example where independent moral principles contribute and enrich the rule of law. But as I said, the rule of law also contributes to morality and generates derivative moral principles. Don't think that derivative means unimportant. Most of the moral principles that we live by are derivative moral principles. Never mind, we are not going there, but that just explains that my use of derivative doesn't mean unimportant. This may happen in various ways, but again, to give just one example, the most common way is due to the fact that when observed, the rule of law generates expectations that its principles will be observed, and we will often justifiably rely on them being observed in a variety of individual cases. So through the principles of respecting justified expectations, the conventions of the rule of law acquire an independent moral force, independent that of the rationale of the doctrine of the rule of law, and deriving from the general principle of respecting justified expectations. I must add two caveats. First, my remarks emphasized some benefits of similarity in the application of the doctrine to various branches of the law and to the law of different countries. But the principles through which the rule of law is applied allow considerable room for flexibility and adaptability. Their application to banking law may differ in suitable ways from their application to dealing with juvenile delinquency, and their application in common law jurisdictions may differ from their application in civil law jurisdictions, without compromising the rationale which underlies them. The rule of law can be observed while respecting significant variations between countries and that express variations which express respect for their local traditions. It is easy to see the flexibility in application of the doctrine when we consider that it applies not only to the law of states, but also to the law of, say, voluntary associations. Their law, the law of associations, is also meant to serve some common good and should not be arbitrary or self-serving. Yet we would not expect that the rule-making ways of associations or their methods of dispute resolution would conform to precisely the same principles that we must insist apply to the rule of states, to the law of states. Besides, the fact that the implementation of the rule of law is mediated by conventions that establish rebuttable presumptions give plenty of room to adaptability to local conditions. So, for example, in some countries, disputes of certain kinds are settled by litigation in front of judge and jury. Deviation is a violation of the rule of law. In other countries, juries are unheard of, and disputes of that very same kind or different kinds are settled by panels of experts, and in them, deviation from this procedure is a breach of the rule of law. So I'm emphasizing the adaptability of the rule of law to local traditions, for it is a condition for it qualifying as a universal moral doctrine, and helps refute criticism that it is a manifestation of one culture imposing its norms on others. But it is time to mention briefly my second caveat. While conformity to the rule of law has clear moral benefits, it does not guarantee that justice, democracy, and respect for human rights prevail. To avoid injustice and other moral blemishes, the role must possess other moral virtues as well. So this is a reason for its great value. All the advantages of conforming to the rule of law that I mentioned are byproducts of the main virtue, acting with a manifest intention to protect and advance the interests of the governed. Based in the main on only two premises, that governments may act only in the interests of the governed, and that honest mistakes about what it is and what it entails are the stuff of ordinary politics, and honest mistakes about this do not violate the rule of law, I concluded that the virtue of the rule of law lies in tending to secure that governments act with a manifest intention of serving the interests of the governed. It would, of course, be nice if everyone agreed with that idea, with that understanding. But not everyone does. My defense of the doctrine of the rule of law depends on the soundness of the premises, not on everyone's agreement with them. Still, the doctrine, as I understand it, does serve to protect the concerns of people who dispute the premises. For example, if one deeply believes that the only purpose of the law is to do God's will, then serving God's will is one of that person's interests, and the law in serving people's interests will serve that interest as well as others. This would not eliminate the disagreement, but it will facilitate peaceful coexistence. It would be foolish to claim that conformity to the rule of law can eliminate arbitrary use of power altogether, but it greatly helps in reducing it. Perhaps more disturbingly, sometimes action in breach of the rule of law can in fact serve the interests of the governed well. Sometimes violation of the rule of law is the only way in which important interests of the people can be protected. The rule of law is an important moral doctrine, but on occasion its violation may be justified. To conclude, the rule of law protects us from arbitrary use of power and from similar abuses of power. It makes it a moral doctrine of great importance. Confidence that the law observes it is a condition of confidence in the law and the government generally, and thus a condition of their ability to govern well. So while the rule of law does not secure conformity to the other moral principles that the law should conform to, it is close to being a condition for the law's ability to conform to them. That view, the rule of law is a condition for the law ability to protect and follow other moral principles, is recognized in innumerable international documents which urge that securing the rule of law is a condition of respect for human rights, for principles of justice, and more. Perhaps not surprisingly, precisely the fact that the rule of law protects us from wrongs which the law's existence creates the opportunities for makes it the specific virtue of the law as law. It protects us from evils that are possible because we have law, and that makes it a specific virtue of law as law, and a universal doctrine applying to all legal systems, the law's own virtue, respect for which is needed for the law to have any other virtues. Thank you.
Thank you very much to Dr. Raz. Please take your seat. Thank you. And now we would like to invite back to the stage Professor Paul Craig to give us the conclusion. Ladies and gentlemen, please welcome Professor Craig.
Thank you very much indeed, Joseph, for that very stimulating and interesting lecture. It's a testimony to a great scholar, that a great scholar will revisit a concept in which he made a seminal, or to which he made a seminal contribution 4 decades ago in the famous Law Quarterly Review article on the rule of law. And it was truly fascinating for me to be privileged to be in the audience today and to listen to Joseph embellish, refine, and develop the concept that he first wrote so authoritatively about in the late 1970s. So thank you again, Joseph, and congratulations for being the 2018 laureate for the rule of law. Thank you.
Thank you very much, Professor Craig. And thank you again to Dr. Raz. Ladies and gentlemen, this is the end of the Rule of Law lecture. Thank you for your participation. If you have any questions regarding this lecture, you're welcome to join the press conference on the first floor.